My name is Priya Sharma and I am 30 years old. For years ago, I sat in a coffee shop in Austin, Texas, with my college best friend, a whiteboard marker, and an idea that I genuinely believed was going to change both of our lives. We split a blueberry muffin. We argued about the product roadmap for 3 hours. We shook hands across the table like the founding moment it was supposed to be. I wrote every line of the product that came out of that coffee shop. I architected the entire backend. I built the MVP in 11 weeks while working a full-time job, sleeping 4 hours a night, and telling myself that the equity would make it worth it. I pitched to our first 3 investors standing next to my co-founder, answering every technical question while she handled the vision slides. The week our company raised $4 million in a Series A, I found out my name was not in the incorporation documents. Not as a co-founder. Not as an employee. Not anywhere. The company I had spent 4 years building existed, legally, entirely under one name. And that name was not mine. Her name was Cassandra Wells. We had been best friends since sophomore year of college. She had been the maid of honor at her sister's wedding, and I had flown across the country to be there. She had held my hand through a breakup that wrecked me for 6 months. She knew the names of my parents, my grandmother's recipe for dal, the specific way I laugh when something is genuinely funny versus when I am being polite. She also knew that I had not read the incorporation papers closely enough. And she had been counting on that. I found out the way you find out things you were never supposed to know, by accident, at the worst possible moment, in a way that made it impossible to pretend I hadn't seen it. Before I tell you what I found and what I did with it, tell me where you're watching from right now. Drop it in the comments, I read every single one. And subscribe to Karma Archives before we go any further, because this story took 3 months to execute, and I am going to take you through every single week of it. Now let me go back to the beginning. Because the beginning is a coffee shop and a blueberry muffin and a friendship I thought was the most solid thing in my life. Cassandra and I met in a software engineering program at UT Austin. She was the loudest person in the room at every hackathon, the one who presented, who networked, who remembered everyone's name and made them feel like knowing her was an opportunity. I was the one who built the thing she presented. We fell into a rhythm almost immediately, the way certain pairs of people do in college when their skills fit together so cleanly that neither of them questions whether the fit is healthy. She had the vision. I had the execution. She had the room. I had the code. She pitched. I built. And for 4 years of college, that arrangement produced results, hackathon wins, internship referrals, a professor's recommendation that got us both into the same accelerator program the summer after graduation. The startup idea came out of that accelerator. A B2B SaaS platform for small legal firms, document automation, client intake, billing integration. Boring to describe, desperately needed in the market, and technically complex enough that most of the competitors were doing it badly. Cassandra had seen the problem firsthand through a summer internship at a law firm. I had the technical background to build the solution. It was, on paper, the perfect co-founding dynamic. We agreed on everything verbally. 50-50 split. Equal co-founders. She would handle business development, fundraising, client relationships. I would handle product, engineering, architecture. We shook hands at the coffee shop. We ordered more coffee. We were excited in the specific, dangerous way that founders are excited before they understand how many things can go wrong. I should have insisted on a written co-founder agreement before I wrote a single line of code. Every founder reading this right now knows that sentence. Every founder who has been through something like what I went through knows it as a specific, physical sensation, the feeling of knowing exactly the moment you should have stopped and made something formal before you proceeded on trust. I did not stop. I proceeded on trust. Because she was my best friend and I was 26 years old, and I believed that some things didn't need paperwork. What Cassandra understood, and what I would only understand 3.5 years later, reading a Crunchbase article about our Series A on a Tuesday afternoon while I was supposed to be reviewing pull requests, was that in the absence of paperwork, everything defaults to whoever filed the documents. She had filed the documents. Alone. 18 months into our working relationship, when we were pivoting the product and I was deep in an architecture rewrite and she had told me she was handling the legal admin. I had thanked her. I had gone back to my code editor. And she had incorporated Wellspring Technologies as a Delaware C Corp with a single founder, Cassandra Wells. I did not know this until I read a Crunchbase article that described her as the founder and CEO of a company I had co-built, in which her bio listed her background in business development and legal tech and did not mention me at all. I closed my laptop. I sat in the quiet of my apartment for approximately 6 minutes. And then I opened it again and I started reading everything I could find. The Crunchbase article led me to the press release. The press release led me to the Series A announcement on TechCrunch. The TechCrunch article quoted Cassandra extensively, her vision, her journey, her team. I was mentioned once, in a single sentence, as the company's lead engineer. Not co-founder. Not CTO, a title we had always used internally. Lead engineer. I searched the Delaware Secretary of State's corporation database. It took 4 minutes to find Wellspring Technologies. The registered agent. The date of incorporation. The sole incorporator. Cassandra Wells. I searched for my name in every variation. It was not there. Not in the original incorporation. Not in any amendment I could find publicly. Not anywhere in the legal structure of the company I had spent 4 years of my life building. I want to tell you what that moment felt like with precision, because I think people sometimes describe these discoveries in ways that make them sound cinematic, a dramatic crash, a flood of tears, a sudden decisive fury. That is not what happened. What happened was something quieter and more specific. It felt like a math error. Like looking at an equation you have run 100 times and suddenly seeing that one of the inputs was wrong from the beginning and everything that came out of it was therefore also wrong. Not destroyed, wrong. Correctable, potentially, but only if you understand the error completely before you start trying to fix it. I did not cry. I did not call anyone. I opened a new folder on my personal drive, not my work machine, my personal one, and I titled it with the date and 2 words. Everything. Mine. Then I made a list of every person I needed to contact and in what order. And I went to bed, because I had learned from the years of building in conditions of insufficient sleep that the decisions made at 2 in the morning are rarely the right ones. I woke up at 6. I made coffee. And I started. The first call was to a startup attorney named Rachel Goldstein. I had her number from a legal clinic at the accelerator 2 years earlier and had never needed to use it. She answered on the 3rd ring, which I later learned was unusual for her. She was someone who let most calls go to voicemail. Something in the way I had worded my voicemail the previous evening had apparently conveyed urgency she recognized. I told her what I had found. She asked me 3 questions. How long had I been building the product? Did I have any written communication establishing the co-founding relationship? And this was the question that told me she already understood the shape of what I was dealing with. Did I have my commit history? I said yes to all 3. 12 weeks of commit history on a private GitHub repository, dating back to before the company was incorporated. 18 months of Slack messages in which Cassandra had referred to us both as founders, in which we had discussed equity, in which she had explicitly confirmed the 50-50 arrangement in writing 14 separate times across 14 different conversations. 3 years of email threads with investors in which I had been introduced as co-founder and CTO. 2 signed NDAs with early clients in which both of our names appeared as representatives of the company. Rachel was quiet for about 10 seconds. Then she said, Priya, she made a significant legal error. The incorporation document doesn't override the totality of evidence establishing your co-founding relationship. What you're describing is a co-founder dispute, and what you have is unusually strong documentation for one. I asked her what that meant in practice. She said, it means we can freeze the Series A until this is resolved. No investor closes a $4 million round with an unresolved co-founder dispute on the cap table. The moment we file, the clock stops. I asked her how long resolution would take. She said, depends on whether Cassandra fights it or negotiates. Based on what you've told me, fighting it would be a losing position for her. The documentation is too strong. I said, what do I need to do? She said, give me everything you just described. Every Slack message, every email thread, every commit log, every signed document with both names. I need the full picture before we file anything. I said I would have it to her by Friday. It was Tuesday. I want to talk about what those 3 days of documentation gathering actually felt like, because I think this part of the story is the part most people don't talk about honestly. I was still going to work. I was still committing code to the Wellspring repository. I was still attending the post-Series A planning meetings that Cassandra was running with the energy of a woman who believed she had secured something permanently. She sent me a Slack message on Wednesday morning that said, big things coming, P. So glad we did this together. I read that message 6 times. I did not respond for 4 hours. When I did, I said, exciting week. That was the entirety of my communication with Cassandra about the funding that week. 2 words. While I spent every evening in my apartment building the most comprehensive document package I have ever assembled in my life, I exported every Slack message between us that contained the words co-founder, equity, 50-50, our company, or we. There were 412 of them. I organized them chronologically. I highlighted every instance where she had explicitly confirmed the arrangement we had agreed to in that coffee shop. I pulled the GitHub commit history and generated a contribution report. Over 4 years of development, I had authored 91% of the codebase. Every architectural decision, every database schema, every integration, every line of the product that investors had just valued at $4 million. I compiled the investor email threads, 27 separate chains over 3 fundraising rounds in which I had been introduced as, referred to as, or signed off as co-founder and CTO. I included the slide deck from our seed pitch, in which both our names appeared on the founding team slide, which Cassandra had presented to 11 investors. I found the signed NDAs. I found a letter of intent from our first enterprise client in which both our names appeared as signatories. On Thursday evening, I sent Rachel a folder containing 463 pages of documentation. She called me Friday morning at 8 o'clock. She said, this is one of the cleanest co-founder dispute cases I have ever seen. She has no viable defense. I asked her to explain what came next. She said, we send a demand letter. We notify the lead investor of the dispute. We file in Delaware Chancery Court if necessary. But Priya, I don't think it will go to court. When she sees what you have, and when her attorney explains to her what the investors will do when they learn about this, she will negotiate. I asked what a reasonable negotiation looked like. She said, 40% of the company. Co-founder title restored formally. CTO designation in writing. A revised cap table that reflects the actual history of this company. I said, what if she says no? Rachel said, then the Series A doesn't close. No investor in the world will close a $4 million round with a co-founder dispute in active litigation. She needs that money. The leverage is yours. I sat with that for a moment. For years of building. For years of commits and architecture decisions and late nights and sprint reviews and investor pitches. For years of being the engine of a company whose legal documents contained one name, and it was not mine. The leverage was mine. I told Rachel to send the letter. Cassandra called me 14 minutes after Rachel sent the demand letter. I know it was 14 minutes because I was watching my phone, sitting on my couch with a cup of coffee that I did not drink, waiting. Her voice when she called was the voice I had never heard from her before in 10 years of friendship. It was not angry. It was not defensive. It was scared in the specific way that people are scared when they have done something they believed they had gotten away with and suddenly understand that they have not. She said, Priya, what is this? I said, it's a demand letter. My attorney sent it. She said, we need to talk. Not through lawyers. Can we please just talk? I said, my attorney has advised me not to have direct conversations about this without her present. A silence. Then, Priya, I made a mistake with the paperwork. I was going to fix it. There was never a good time and then everything was moving so fast and I said, Cassandra, I know what the documents say. I know what the cap table says. I know what the incorporation says. And I have 463 pages of documentation that tell a different story. My attorney will be in touch with yours. Another silence. Longer this time. Then she said, very quietly, are you really going to do this? I said, I already did. And I hung up. I want to be honest about what happened after I hung up because I've told this story a few times and I always skip this part because it is the part that makes me feel most human and least like the composed, strategic person the rest of the story makes me sound like. What happened was that I set my phone down on the couch and I cried for about 20 minutes. Not out of doubt. I was not uncertain about what I was doing. I cried because she had been my best friend for 10 years. Because I had flown across the country to stand beside her at a wedding. Because the person who had just told me she was going to fix it was someone I had trusted completely, and the grief of that specific loss, not the company, not the equity, but the friendship, was real and present and had nothing to do with the legal strategy. Then I washed my face. I made fresh coffee. And I went back to work because the product still needed to be built regardless of what was happening in the legal layer of the company that ran on top of it. That is the thing about being the person who builds things. The building does not stop just because everything else is falling apart. If anything, it becomes the one place where the math is still clean, where the inputs produce the expected outputs, where you know exactly what you are doing and why. I built things for 3 more months while the legal process ran. Cassandra's attorney reached out to Rachel within 48 hours of the demand letter. The negotiation that followed was not, as Rachel had predicted, a long one. It lasted 3 weeks. It was conducted entirely through the attorneys. I did not speak to Cassandra again during that period. What made it short was the investors. The lead investor on the Series A was a partner at a mid-size VC firm named Carter Moss. Rachel notified Carter Moss's legal team of the dispute on the same day she sent the demand letter. Carter Moss's legal team notified Carter. And Carter, who had just committed $4 million to a company on the basis of a founding team that included a technical co-founder who turned out to not legally exist in the company's structure, had a very clear and very immediate response. The closing was paused. That was the word they used. Paused. Which in venture capital means, we are not putting money into this until the situation that creates legal uncertainty about the company's ownership is fully resolved. No investor closes into a company with an active co-founder dispute. The liability exposure is too significant. The cap table ambiguity is too significant. And $4 million is too much money to close on anything less than a clean legal structure. Cassandra needed that money. The company's runway was 6 weeks. 6 weeks of payroll and operating expenses and vendor contracts and everything else that runs on the assumption that the Series A will close on schedule. The leverage was mine because the timeline was hers. In week 2 of the negotiation, Cassandra's attorney proposed 30%. Rachel said 40% or we file in Delaware Chancery, and the timeline extends by a minimum of 6 months. In week 3, Cassandra's attorney proposed 35% with a note from Cassandra personally asking if we could also preserve the friendship. Rachel presented the counter. 40%, co-founder title formally restored in all company documents, CTO designation with accompanying employment agreement, and a board seat. Non-negotiable. Cassandra accepted on a Thursday afternoon in the 3rd week. I want to pause here because I've been telling this story in a way that makes the outcome sound inevitable, and I want to be honest about the fact that it was not. There were 3 weeks during which I genuinely did not know if Cassandra would fight it. There were nights during which I lay awake doing the math on what would happen if she chose to litigate the timeline, the cost, the possibility that a judge might weigh certain factors differently than Rachel projected. There were moments of doubt that I did not share with anyone because I had learned, in those months, that doubt is best processed alone and quickly, like a bug in code that you find and fix and do not dwell on. What I came back to, every time the doubt arrived, was the folder. 463 pages. 91% of the codebase. 14 written confirmations of the equity arrangement. 27 investor email chains. The blueberry muffin conversation, which I had written down in a personal journal entry the night after it happened, because I was someone who wrote things down and always had been. The documentation was not just legal strategy. It was proof, to myself, that I was not wrong about what had happened. That I had not misremembered. That the thing I believed to be true about the company and my role in it was verifiable and real. When you are in a dispute with someone who was once your closest friend, the most destabilizing thing is the possibility that you have somehow misread the history. The documentation made that impossible. I could not doubt myself because I had the receipts, and the receipts were unambiguous. Keep your records. That is the sentence I want you to take out of this section. Keep them on your personal drive. Keep your commit history. Write down the handshake agreements in a journal entry the same night. Forward important verbal confirmations to yourself via email so they have a timestamp. You are not being paranoid. You are being a person who understands that trust and documentation are not opposites. The most trustworthy people I know keep the most thorough records. Because records are not about distrust, they're about clarity. And when you need clarity most is always when someone else has decided that the facts are negotiable. The amended incorporation documents were filed on a Friday morning in Delaware. The revised cap table was executed the same day. My employment agreement as CTO was signed and countersigned. The board seat was formalized. And on the following Monday, Carter Moss's legal team confirmed that all conditions precedent had been satisfied and the Series A closing would proceed on the original terms. For $1 million closed into Wellspring Technologies on a Wednesday. I received a notification because I was now, formally and legally, a board member. I did not celebrate. I went to my code editor, and I continued working on the feature sprint we had delayed during the negotiation period. There was a client demo in 2 weeks and the product needed to be ready. The work was the same as it had always been. The difference was that now it had my name on it. Cassandra and I did not speak directly for 3 months after the settlement. When we did begin to communicate again, through the company Slack, in board meetings, in the necessary logistics of running a startup together, it was with the specific professionalism of two people who have agreed to prioritize the company over the history between them. I do not know if that was the right choice. I do not know if we will ever be what we were before. What I know is that the company is real, the product is real, the team we have built since the Series A is real, and my name is on all of it. That is enough. For now, it is enough. 18 months after the Series A, Wellspring Technologies closed a Series B. The round was led by a different firm, one that had tracked our growth since the Series A and had been in ongoing conversations with both Cassandra and me as a founding team. In the meetings I attended with that firm, I was introduced as co-founder and CTO. My name appeared on the term sheet. My board vote was required for the close. I signed the Series B documents at a conference table in a law firm's office downtown. I used my own pen. I signed my name clearly, with the deliberate satisfaction of someone who has written it in enough places that it cannot be removed from anything going forward. Afterward, I went to a coffee shop, not the same one, a different one that was mine alone. And I ordered a blueberry muffin and a coffee, and I sat at a corner table, and I thought about the 30-year-old woman who had spent 11 weeks sleeping 4 hours a night to build something she believed in. I thought about what she deserved for that. She deserved exactly what she got. It just took 4 years, a demand letter, and 463 pages to make it official. I want to tell you something before I go, to anyone watching this who is in the early stages of building something with someone they trust. Friendship and equity are not the same thing. They feel the same when everything is going well, when you are in the coffee shop with the blueberry muffin and the shared vision and the excitement that makes everything feel solid and permanent. But they're not the same thing. And when they diverge, if they diverge, not everyone's story goes where mine did. The only thing that will protect you is what you put in writing before you needed it. Get the co-founder agreement. Get it before you write the first line of code, before you register the domain, before you spend 1 hour of your life building something that might one day be worth protecting. It does not mean you distrust your co-founder. It means you are both serious enough about what you are building to protect it properly. Know what you contributed. Document it, not obsessively, not constantly, but consistently. The commit history. The email threads. The Slack messages. The journal entry the night of the handshake. And if you ever find yourself in the position I found myself in reading a Crunchbase article about your own company and not finding your name in it, understand that the documentation you kept quietly over years, for no particular reason except that you were the kind of person who kept things, is the most powerful legal instrument you have. The thing you built is yours. Even when someone else's name is on the door. Make sure the door gets corrected. Leave a comment and tell me, have you ever built something with someone you trusted and had to fight to prove it was yours? Or have you ever almost entered a founding relationship without paperwork and caught yourself? I want to hear it. I read every single one. And if this story found you somewhere real, somewhere that made you sit up a little straighter, or pick up your phone and check what you've been building for the last year, subscribe to Karma Archives. Every week there is another story like this one. Women who built quietly, who documented carefully, who waited for the right moment and were ready when it came. Women whose names ended up on the documents. All of them. Karma always has more to say. And we will be here every single week to show you exactly what it looks like when it finally does. Subscribe. I'll see you next time.